Verba Juris, Review Notes, Volume 1, Civil Law, Second Sunday, Civil Law, Syllabi Guide Review, List of relevant laws and issuances for civil law. Second Sunday, Bar Examinations. Civil Law. Civil Law. While the law may be sometimes hard for the individual, it is best for the race because it ensures the survival of the fittest in every department. We accept and welcome, therefore, as conditions to which we must accommodate ourselves great inequality of environment, the concentration of business, industrial and commercial, in the hands of a few, and the law of competition between these as being not only beneficial but essential for the future progress of the race. Andrew Carnegie, Wealth from the North American Review. So under civil law, we have partnership, credit transactions, except for loan and deposit, on concurrence and preference of credits will be part of commercial law. Civil code. Provisions of labor will not be covered in civil law. The procedure for foreclosure of mortgage, real, personal, will be in the religious law. To 18. Partnerships. When law takes effect, in general, when law takes effect, law shall take effect after 15 days. After 15 days. Following the completion of their publication in the Official Gazette, unless it is otherwise provided, this code shall take effect 1 year after such publication. In contrast, the Civil Code is a general law that covers general rules on the effect and application of laws and human relations, persons and family relations, property and property relations, the different modes of acquiring ownership and obligations and contracts. Its general nature is best appreciated when in its Article 18 Civil Code. Persons, application of laws and human relations. Human relations, persons and family relations. Property and property relations. Different modes. Ownership. In general nature, it is best appreciated. Retoractivity of laws. As a general rule, laws shall have no retroactive effect. However, exceptions exist, and one such exception concerns a law that is procedural in nature. A statute or rule regulating the procedure of the courts will be construed as application to actions pending and undetermined at the time of its passage. All procedural laws are retroactive in that sense, and to that extent, the retroactive application is not violative of any right of a person who may feel adversely affected, for verily no vested right generally attaches to or arises from procedural laws. Article 4 of the Civil Code states that laws shall have no retroactive effect unless the contrary is provided. Repeal of laws. Laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. Conflict of laws. According to the new Civil Code, the law of the country to which the goods are to be transported shall govern the liability of the common carrier for their loss, destruction, or deterioration. Transnational transactions entail differing laws on the requirements for the validity of the formalities and substantive provisions of contracts and their interpretation. Courts may choose to assume jurisdiction subject to the following requisites. First, that the Philippine court is one to which the parties may conveniently resort to. Second, that the Philippine court is in a position to make an intelligent decision as to the law and the facts. Third, that the Philippine court has or is likely to have power to enforce its decision. The choice of law issue in a conflict of laws case seeks to answer the following important questions. First, what legal system should control a given situation where where some of the significant facts occurred in two or more states. Second, to what extent should be the chosen legal system regulate the situation. For Philippine courts to recognize a foreign judgment relating to the status of a marriage where one of the parties is a citizen of a foreign country, the petitioner only needs to prove the foreign judgment as a fact under the rules of court. A foreign judgment relating to status of marriage affects the civil status, condition, and legal capacity of its parties. However, the effect of a foreign judgment is not automatic. To extend the effect of a foreign judgment in the Philippines, Philippine courts must determine if the foreign judgment is consistent with domestic public policy and other mandatory laws. The Civil Code continued to follow the nationality rule to the effect that Philippine laws relating to family rights and duties or to the status, condition, or legal capacity of persons were binding upon citizens of the Philippines although living abroad. Human relations. Article 9 of the Civil Code provides that every person in the exercise of his rights and in the performance of his duties must act with justice, give everyone his due, and observe honesty and good faith. The concept of abuse of rights prescribes that a person should not use his right unjustly or in bad faith. Otherwise, he may be liable to another who suffers injury. It is Hornbook doctrine that a person committing a void act contrary to a mandatory provision of law cannot claim or acquire any right from his void act. A right cannot spring in favor of a person from his own void or illegal act. Unjust enrichment is a term used to depict result or effect of failure to make remuneration or for property or benefits received under circumstances that give rise to legal or equitable obligation to account for them. Applicability of penal laws. Persons and family relations. Persons. Kinds of persons. There are two kinds of persons contemplated under the law, natural and juridical. The former are human beings whose personality is determined by birth and extinguished by death, while the latter are created by fiction of law. Capacity to act. Juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effect,
This
is
is
acquired
Legos,
and may be
the
lost.
free-to-play multiplayer game where you can unlock Earn and sell NFTs in-game, in Legos, in pays to play. Literally, you can choose to sell your...
Rights and obligations of couples in intimate relationships. Republic Act number 9262, marriage. Requisites: the absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35. A defect in any of the essential requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. Marriage is celebrated abroad. A Filipino who is married to another Filipino is not similarly situated with a Filipino who is married to a foreign citizen. There are real, material, and substantial differences between them. Ergo, they should not be treated alike, both as to rights conferred and liabilities imposed. Without a doubt, there are political, economic, and cultural and religious dissimilarities, as well as varying legal systems and procedures. All too often unfamiliar that a Filipino national who is married to an alien spouse has to contend with more importantly, while a divorce decree obtained abroad by a Filipino against another Filipino is null and void. A divorce decree obtained by an alien against his or her Filipino spouse is recognized if made in accordance with the national law of the foreigner. Foreign divorce. On the contrary, there is no real and substantial difference between a Filipino who initiated a foreign divorce proceedings and a Filipino who obtained a divorce decree upon the instance of his or her alien spouse. In the eyes of the Philippine and foreign laws, both are considered as Filipinos who have the same rights and obligations in an alien land. The circumstances surrounding them are alike. Per paragraph 2 of Article 26, both are still married to their foreigner spouse who are no longer their wives' husbands. Hence, to make a distinction between them based merely on the superficial difference of whether they initiated the divorce proceedings or not is utterly unfair. Indeed, the treatment gives undue favor to one and unjustly discriminates against the other. Void marriages. Under Article 35 of the Family Code, the following marriages shall be void from the beginning: those contracted by any party below 18 years of age, even with the consent of parents or guardians; those solemnized by any person not legally authorized to perform marriages, unless such marriages were contracted with either of both parties believing in good faith that the solemnizing officer had the legal authority to do so; those solemnized without license except those under extraordinary circumstances; and fourth, those bigamous or polygamous marriages not failing under Article 41 of the Family Code; fifth, those contracted through mistake of one contracting party as to the identity of the other; and sixth, those subsequent marriages that are void under Article 53 of the Family Code. Void and voidable marriages. The following marriages shall be void from the beginning: first, those contracted by any party below 18 years of age, even with the consent of parents or guardians. Second, those solemnized by any person not legally authorized to perform marriages. Unless such marriages were contracted with either of both parties believing in good faith that the solemnizing officer had the legal authority to do so. Those solemnized without license except those covered the preceding chapter. Those bigamous or polygamous marriages not failing under Article 41. Those contracted from the state of one contracting party as to the identity of the other, and those subsequent marriages that are void under Article 52. The following marriages shall be void from the beginning, for reasons of public policy between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree, between step-parents and step-children, between parents-in-law and children-in-law, between the adopting parent and the adopted child, between the surviving spouse, the adopting parent and the adopted child. Sixth, between the surviving spouse of the adopted child and the adopter, between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter. And 9. Between parties where one, with the intention to marry the other, kill that other person's spouse or his or her own spouse. A marriage may be annulled for any of the following causes existing at the time of the marriage: that the party in whose behalf, if it is so to have the marriage annulled, was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardians, or person having substitute parental authority over the party in that order, unless after attaining the age of 21 such party freely cohabited with the other and both lived together as husband and wife. That either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband and wife. Third, that the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Fourth, that the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. Fifth, that either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. Or sixth, that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Legal separation. A petition for legal separation may be filed on any of the following grounds. First, repeated physical violence or grossly abusive conduct. Conduct directed against the petitioner, a common child or a child of the petitioner. Physical violence or moral pressure to compel the petitioner to change religious or political affiliation. Attempt of respondent to corrupt or induce the petitioner, a common child or a child of the petitioner, to engage in prostitution or connivance in such corruption or inducement. Final judgment. Fourth, final judgment sentencing the respondent to imprisonment of more than 6 years, even if pardoned. Fifth, drug addiction or habitual alcoholism of the respondent. Sixth, lesbianism or homosexuality of the respondent. Seventh, contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. Eighth, sexual infidelity or perversion. Ninth, attempt by the respondent against the life of the petitioner. Or 10th, abandonment of petitioner by respondent without justifiable cause for more than 1 year. Purposes of this article: the third child shall include a child by nature or by adoption. The petition for legal separation shall be denied on any of the following grounds: where the aggrieved party has condoned the offense or act complained of, where the aggrieved party has consented to the commission of the offense or act complained of, where there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation. Fourth, where both parties have given ground for legal separation. And fifth, where there is collusion between the parties to obtain decree of legal separation. 6. Where the action is barred by prescription. Procedure. However, in actions for declaration of nullity or annulment of marriage or for legal separation, the material facts alleged in the complaint shall always be proved. A judgment of the pleadings is a judgment of the facts as pleaded, and is based exclusively upon the allegations appearing in the pleadings of the parties and the accompanying annexes. It is settled at the trial court. Instead of divorce, the present family code only provides for legal separation, Title II, and even this expression prescribes that the marriage bonds shall not be severed. Effects of filing petition. However, in actions for declaration of nullity or annulment of marriage or for legal separation, the material facts alleged in the complaint shall always be proved. A judgment on the pleadings is a judgment on the facts as pleaded, and is based exclusively upon the allegations appearing in the pleadings of the parties and the accompanying annexes. Effects of pendency. During the pendency of the action for legal separation, the provisions of Article 49 shall likewise apply to the support of the spouses and the custody and support of the common children. During the pendency of the action and in the absence of adequate provisions in a written agreement between the spouses, the court shall provide for the support of the spouses and the custody and support of their common children. The court shall give paramount consideration to the moral and material welfare of said children and their choice of the parent with whom they wish to remain as provided 2 in Title IX. It shall also provide for appropriate visitation rights of the other parent. Effects of decree of legal separation. Instead of divorce, the present family code only provides for legal separation, Title II, and even this expressly prescribes when the marriage bonds shall not be severed. The decree of legal separation shall have the following effects. The spouses shall be entitled to live separately from each other, but the marriage bonds shall not be severed. The absolute community or the conjugal partnership shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the net profits earned by the absolute community or the conjugal partnership, which shall be forfeited in accordance with the provisions of Article 43, Paragraph 2. The custody of the minor children shall be awarded to the innocent spouse, subject to the provisions of Article 213 of this Code. And fourth, the offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Moreover, provisions in favor of the offending spouse made in the will of the innocent spouse shall be revoked by operation of law. Reconciliation. If the spouses should reconcile, a corresponding joint manifestation under oath, duly signed by them, shall be filed with the court in the same proceeding for legal separation. The reconciliation referred to in the preceding articles shall have the following consequences. First, that the legal separation proceedings, if still pending, shall thereby be terminated at whatever stage, and the final decree of legal separation shall be set aside, but the separation of property and any forfeiture of the share of the guilty spouse already affected shall subsist unless the spouses agree to revive their former property regime. The court's order containing the foregoing shall be recorded in the proper civil registries. Rights and obligations between husband and wife. In fine, marriage is not just an adventure but also a lifetime commitment. Same is definitely not for children but for two consenting adults who view the relationship with love, respect, sacrifice, and continuing commitment to compromise, conscious of its value as a sublime social institution, while the law provides that the husband and the wife are obliged to live together, observe mutual love, respect, and fidelity. Spouses should reconcile. A corresponding joint manifestation under oath duly signed by them shall be filed before court in the same proceeding for legal separation. The reconciliation referred to in the preceding articles shall have the following consequences. The legal separation proceedings, if still pending, shall thereby be terminated at whatever stage. Final decree of legal separation shall be set aside on the separation of property. Any forfeiture of the share of the guilty spouse already effected shall subsist unless the spouses agree to revive their former property regime. The court's order containing the foregoing shall be recorded in the proper civil registries. Rights and obligations between husband and wife. In fine, marriage is not just an adventure, but also a lifetime commitment. The same is definitely not for children, but for two consenting adults who view the relationship with love, respect, sacrifice, and continuing commitment to compromise conscious of its value as a sublime social institution, while the law provides that the husband and the wife are obliged to live together, observe mutual love, respect, and fidelity. Property relations of the spouses. Marriage settlements. The words married to preceding the name of a spouse are merely descriptive of the civil status of the registered owner. Such words do not prove co-ownership. Relations by reason of marriage. Donations of immovables under the family code, including those made by reason of marriage, must now be expressly accepted by in a public instrument. Void donations by the spouses. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife without the valid marriage. Absolute community property. Absolute community of property. Actual contribution is not relevant in determining whether a piece of property is community property, for the law itself defines what constitutes community property. It is clear under the family code that Rogelio would not sell the subject property without the written consent of respondent or the authority of the court. Without such consent or authority, the entire sale is void. Blesa versus Nueva. Under Article 94 of the Family Code, the absolute community of property shall only be liable debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. Conjugal partnership of gains. All property of the marriage is presumed to belong to the conjugal partnership unless it be proved that it pertains exclusive to the husband or to the wife. Under Article 130 of the Family Code, the conjugal partnership property upon its dissolution due to the death of either spouse should be liquidated in the same proceeding for the settlement of the estate of the deceased or the absence thereof by the surviving spouse within 1 year from the death of the deceased spouse. The Under the regime of conjugal partnership of gains, the husband and wife are co-owners of all the property of the conjugal partnership. In Spouses Chain versus Court of Appeals, the Supreme Court elucidated that there is no presumption that the conjugal partnership is benefited when a spouse enters into a contract of surety, property regime of unions without marriage, due to the civil marriage between attorney Luna and the petitioner being void ab initio by virtue of it being bigamous. The properties acquired during the bigamous marriage were governed by the rules of co-ownership conformably with Article 144 of the Civil Code. Family. Concept of family. Family, being the foundation of the nation, is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law, and no custom, practice, or agreement destructive of the family shall be recognized or given effect. Effects on legal disputes. No suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts towards a compromise have been made, but that same have failed if it is shown that no such efforts were in fact made. The same case must be dismissed. Family home. Article 155 of the Family Code explicitly provides that debts secured by mortgages are exempted from the rule against execution, forced sale, or attachment of family home. The family home constituted jointly by the husband and the wife or by an unmarried head of a family is the dwelling house where they and their family reside and the land on which it is situated. The family home is deemed constituted on a house and land from the time it is occupied as a family residence from the time of its constitution, and so long as any of its beneficiaries actually resides therein. The family home continues to be such that is exempt from execution, forced sale, or attachment except as hereinafter provided, and to the extent of the value allowed by law. Paternity and filiation. Legitimate children. A legitimate child is one that is born in lawful wedlock or within a competent time afterwards. The time of birth is the criterion of legitimacy. It is sufficient that the child is born after, though begotten before the celebration of the marriage. Proof of filiation. View that statistics have never been used to prove paternity or filiation. Children conceived or born during the marriage of the parents are legitimate. Illegitimate children. On the Defective of the Public Act number 9255, the provision that illegitimate children shall use the surname and shall be under the parental authority of their mother was retained with an added provision that they may use the surname of their father. Their filiation has been expressly recognized by their father. The law is clear that illegitimate children shall use the surname and shall be under the parental authority of the mother. Action to impugn legitimacy. Legitimacy of a child may be impugned only on the following grounds. First, that it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of A. the physical incapacity of the husband to have sexual intercourse with his wife, B. the fact that the husband and wife were living separately in such a way that sexual intercourse was not possible, or C. serious illness of the husband which absolutely prevented sexual intercourse, and 2. that it is proved that for biological or other scientific reasons the child could not have been that of the husband except in the instance provided in the second paragraph, Article 164. Number 3, that in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. Legitimate children. Article 177 of the Family Code provides not only children conceived and born outside of the wedlock of parents who at the time of the conception of the former were not disqualified by any impediment to marry each other may be legitimated, at least for the purpose of resolving the instant petition. The principle of Estoppel finds application and it now bars from making an assertion contrary to his previous representations. C remains to be B's son, and pursuant to Article 170 of the Family Code, the former is entitled to the same rights as no legitimate child, including the receipt of his father's support. Adoption. Adoption is a rule that changes the reciprocal status only of the adopter and the adopted child. It does not extend to the relatives of the adopting parents or of the relatives of the adopting parents or of the adopted child, except only as expressly provided by the law. It must be emphasized that adoption severs all legal ties between the biological parents and the adoptee and vests those rights in the adopter. Section 17 of Republic Act No. 8552 in particular provides that the adoptee shall be considered the legitimate son or daughter of the adopter for all intents and purposes, and as such is entitled to all the rights and obligations provided by law to legitimate sons or daughters born to them without discrimination of any kind. Hence, upon the entry of an adoption decree, the law creates a relationship in which adopted children are deemed born of their adoptive parents. Domestic laws on adoption also support the principle that foundlings are Filipinos. These laws do not provide that adoption confers citizenship upon the adoptee. Rather, the adoptee must be a Filipino in the first place to be adopted. The most basic of such laws is Article 15 of the Civil Code, which provides that laws relating to family rights and duties, status, conditions, legal capacity of persons are binding on citizens of the Philippines, including living abroad. Adoption deals with the status in the Philippine Adoption Court will have jurisdiction only if the adoptee is a Filipino. Support. Compromises. An action for support may very well resolve the ineluctable issue of paternity if it involves the same parties is brought before the court in the proper jurisdiction, prays to impel recognition of paternal relations, and invokes judicial intervention to do so, who are obliged to give support, subject to the provisions of the succeeding articles. The following are obliged to support each other to the whole extent set forth in the preceding article: the spouses, legitimate ascendants and descendants, parents and their legitimate children, and the legitimate and illegitimate children of the latter, parents and their illegitimate children, and the legitimate and illegitimate children of the latter, legitimate brothers and sisters, whether full or half blood, brothers and sisters not legitimately related, whether of the full or half blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister being of age is due to a cause imputable to the claimant's fault or negligence. In case of legitimate descendants, whether legitimate or illegitimate, and brothers and sisters, whether illegitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or the conjugal partnership. In case of legitimate descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obligor has no separate property, the absent community or the conjugal partnership, if financially capable, shall advance the support which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. During the proceedings for legal separation or for annulment of marriage and for declaration of nullity of marriage, the spouses and their children shall be supported from the properties of the absolute community or the conjugal partnership. After the final judgment granting the petition, the obligation of mutual support between the spouses ceases. However, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent one, specifying the terms of such order. Amount of support. Article 202 of the Family Code adds that support may be adjusted and that it shall be reduced or increased proportionately according to the reduction or increase of the necessities of the recipient and the resources or needs of the person obliged to furnish the same. As a matter of law, the amount of support which those related by marriage and family relationship is generally obliged to give each other shall be in proportion to the resources or needs of the giver and to the needs of the recipient. Manner and time of payment. The obligation to give support shall only be demandable from the time the person entitled to it needs it for maintenance. This shall not be paid except on the date of judicial or extrajudicial demand. Procedure and applications for support. The Supreme Court added that an action to compel recognition could very well be integrated with an action for support. Parental authority. General provisions. Article 176 of the Family Code explicitly confers the sole parental authority of an illegitimate child to the mother. This preference favoring the mother is reiterated in Article 213 of the Family Code, which provides that no child under 7 years of age shall be separated from the mother. Parental authority over minor children is lodged by Article 176 of the mother. The mother is lodged by Article 176 of the mother. Since parental authority is given to the mother, then custody over the minor children also goes to the mother unless she is shown to be unfit. Substitute parental authority. In default of parents or a judicially appointed guardian, the following person shall exercise substitute parental authority over the child in the order indicated. The surviving grandparent as provided in Article 214. The oldest brother or sister over 21 years of age unless unfit for or disqualified, and the child's actual custodian over 21 years of age unless unfit or disqualified. Emancipation. Cause of emancipation. In civil law, the release of a person from parental authority whereby he becomes capacitated for civil life, either fully or partially. From this definition, it is clear that it may be either perfect or imperfect. Perfect if the person who is emancipated is fully capacitated for civil life, and imperfect if the person emancipated is partially capacitated for civil life, such as when it is effected by the marriage of a minor or by concession of the father or mother who exercises parental authority, or by order of the proper court in the case of a minor who is an orphan. Effect of emancipation. Emancipation for any cause shall terminate parental authority over the person and property of the child, who shall then be qualified and responsible for all acts of civil life. Summary judicial proceeding. The Family Court. Use of surnames. While judicial authority is required for a change of name or surname, there is no such requirement for the continued use of a surname is a person has already been using since childhood. The doctrine that this allows a judicial authority is required for a change of name or surname. There is no such requirement for the continued use of a surname which a person has already been using since childhood. The doctrine that this allows such change of name as would give the false impression of family relationship remains valid, but only to the extent that the proposed change of name would in great probability cause prejudice or future mischief to the family whose surname it is that is involved, or to the community in general. Absence. Provisional measures in case of absence. Marriage contracted by any person during subsistence of a period previous marriage shall be null and void unless before the celebration of the subsequent marriage the married spouse had been sent absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead. In the case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient for the purpose of contracting the subsequent marriage. Under the preceding paragraph, the spouse present must institute a summary proceeding as provided in the code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. Declaration of absence. 2 years having elapsed without any news about the absentee, or since the receipt of the last news, and 5 years in case the absentee has left the person in charge of the administration of his property, his absence may be declared. The following may ask for the declaration of absence: the spouse present, the heirs instituted in the will, who may present an authentic copy of the same, the relatives who may succeed by the law of intestacy, those who may have over the property of the absentee some right subordinated to the condition of his death. The judicial separation of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. Administration of the property of the absentee. An administrator of the absentee's property shall be appointed in accordance with Article 383. The wife who is appointed as an administrator of the husband's property cannot alienate or encumber the husband's property or that of the conjugal partnership without judicial authority. The administration shall cease in any of the following cases: where the absentee appears personally or by means of an agent, and the death of the absentee is proved in his testate or intestate heirs appear, when a third person appears showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases, the administrator shall cease the performance of his office, and the property shall be at the disposal of those who may have a right thereto. Presumption of death. In Republic versus Tango, the High Court held that the remedy of a losing party in a summary proceeding is not an ordinary appeal, but a petition for certiorari. It held that by express provision of law, the judgment of the court in a summary proceeding shall be immediately final and executory. As a matter of course, it follows that no appeal can be had of the trial court's judgment in a summary proceeding for the declaration of presumptive death of an absent spouse under Article 41 of the Family Code, when subsequent marriages are contracted after a judicial declaration of presumptive death. A presumption arises that the first spouse is already dead and that the second marriage is legal. Next topic is property. Property. Classification of property. Movables. The following are immovable property: land, buildings, roads, and constructions of all kinds adhere to the soil. Trees, plants, and growing fruits, while they are attached to the land or form an integral part of the immovable. Everything attached to an immovable in a fixed manner in such a way that it cannot be separated therefrom without breaking the material or deterioration of the object. Statues, reliefs, paintings, or other objects for use or ornamentation placed in buildings or on lands by the owner of the immovable in such a manner that it reveals the intention to attach them permanently to the tenements. Machinery, receptacles, instruments, or implements intended by the owner of the tenement for industry or works which may be carried on in a building or in a piece of land and which tend directly to meet the needs of the said industry or works. Animal houses, pigeon houses, beehives, fish ponds, or breeding places of similar nature in case their owner has placed them or attached them or preserves them with the intention to have them permanently attached to the land and forming a permanent part of it. The animals in these places are included. Fertilizer actually used on a piece of land, mines, quarries, and slag dumps, while the matter thereof forms part of the bed and waters either running or stagnant. Docks and structures which, though floating, are intended by their nature and object to remain at a fixed place on a river, lake, or coast. Contracts for public works and servitudes and other real rights over immovable property. Movables. The following things are deemed to be personal property. Those movables susceptible of appropriation which are not included in the preceding article. Real property, which by any special provision of law is considered as personality. Forces of nature which are brought under control by science in general. All things which can be transported from place to place without impairment of the real property to which they are fixed. The following are also considered as personal property. Obligations and actions which have for their object movables or demandable sums and shares of stock of agricultural, commercial, and industrial entities, although they may have a real estate. Movable property is either consumable or not consumable. To the first class belong those movables which cannot be used in a manner appropriate to their nature without their being consumed. To the second class belong all the others. Ownership may be exercised over things or rights. The owner has the right to enjoy and dispose of a thing without other limitations than those established by law. The owner has also a right of action against the holder and possessor of the thing in order to recover it. The owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Every owner may enclose or fence his land or tenements by means of walls, ditches, live or dead hedges, or by any other measure. Any other tenements detriment to servitudes constituted thereon. The owner of a thing cannot make use thereof in such manner as to injure the rights of a third person. The owner of a thing has no right to prohibit the interference of another with the same if the interference is necessary to avert an imminent danger and the threatened damage compared to the damage arising to the owner when the interference is much greater. The owner may demand from the person benefited indemnity for the damage to him. Actual possession of their claim of ownership raises disputable presumption of ownership. The true owner must resort to judicial process for the recovery of the property, and an action to recover the property must be identified, and the plaintiff must rely on the strength of his title and not on the weakness of the defendant's claim. No person shall be deprived of his property except by competent authority and for public use and always upon payment of just compensation. Should this requirement be not first complied with, the courts shall protect and in a proper case restore the owner in his possession. When any property is condemned or seized by competent authority, in the interest of health, safety, or security, the owner thereof shall not be entitled to compensation unless he can show that such condemnation or seizure is unjustified. The owner of a parcel of land is the owner of its surface and of everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper, without detriment to servitudes and subject to special laws and ordinances. He cannot complain of the reasonable requirements or of aerial navigation. If the things found be of interest to science or the arts, the state may acquire them at their just price, which shall be divided in conformity with the rules stated. By treasure is understood for legal purposes any hidden and unknown deposit of money, jewelry, or other precious objects, the law for ownership of which does not appear. Accession. Accession. Things appropriable by nature which are without an owner, such as animals that are the object of hunting and fishing, hidden treasure, and abandoned movables are acquired by occupation. Abandoned movables. Abandoned movables are acquired. Hidden treasure belongs to the owner of the land, building, or other property on which it is found. Nevertheless, when the discovery is made of the property of another or of the state, or any of its subdivisions, and by chance one half thereof shall be allowed to the finder, if the finder is a trespasser, he shall not be entitled to any share of the treasure. Rules of accession. The accessory follows the principle that is the ownership of the property gives right by accession to everything which is produced thereby or which is incorporated or attached thereto, either naturally or artificially. For immovables, when there are factual and evidentiary evidence to prove the building and the lot on which it stands are owned by different persons, they shall be treated separately. For movables. Blank. Quieting of title. Quieting of title is a common law remedy for the removal of any cloud upon doubt or uncertainty with respect to title to real property. Requisites distinctions between quieting title and removing preventing a cloud. Prescription or non-prescription of action. Co-ownership. Characteristics of co-ownership: before the partition of a land or thing held in common, no individual or co-owner can claim title to any definite portion thereof, on that the co-owner has is an ideal of quota or proportionate share in the entire land of the thing. Sources of co-ownership. There is co-ownership whenever the ownership of an undivided thing belongs to different persons. In a co-ownership, the undivided thing or right belong to different persons, with each of them holding the property pro indiviso and exercising her rights over the whole property. Rights of co-owners. A co-owner could sell his undivided share. Termination of co-ownership. Prescription cannot be appreciated against co-owners of a property absent any conclusive act of repudiation made clearly known to the owner to the other co-owners. Possession. Characteristics. Possession is an incident of ownership. Whoever owns the property has the right to possess it. Whoever owns a property has the right to possess it. Acquisition of possession. The registered owner of real property is entitled to its possession. Possession is acquired in any of the following ways: by the material occupation of the thing, by the exercise of a right, by the fact that the property is subject to the action of our will, and by the proper acts and legal formalities established for acquiring the right. Even a certificate non-transfer does not vest ownership in its holder. Possession is an incident of ownership. Whoever owns the property has the right to possess it. The person who has a torrent's title over a land is entitled to possession thereof. Possession can be acquired only, not only by material occupation, but also by the fact that the thing is subject to the action of one's will, or by the proper acts and legal formalities established for acquiring such right. Effects of possession. The person who has torrent's title over a land is entitled to possession thereof. The registered owner of the real property is entitled to its possession. However, the owner cannot simply wrest possession thereof from whoever is in actual occupation of the property. Loss or unlawful deprivation of a movable. The possession of movable property acquired in good faith is equivalent to a title. Good faith. Nevertheless, one who has lost any movable or has been unlawfully deprived thereof may recover it from the person in possession of the same. If the possessor of a movable lost or which the owner has been unlawfully deprived has acquired it in good faith at a public sale, the owner cannot obtain its return without reimbursing the price paid therefor. Possession in concept of owner or holder, in one's own name and in name of another. A possessor, in the concept of owner, has in his favor the legal presumption that he possesses with a just title and he cannot be obliged to show or prove it. When a complaint for recovery of possession is filed against a person in possession of a parcel of land under claim of ownership, he or she may validly raise the nullity of title as a defense and by way of counterclaim seek its cancellation. Rights of the possessor. Every possessor has a right to be respected in his possession, and should he be disturbed therein, he shall be protected in or restored to said possession by the means established by the laws and the rules of court. A possessor deprived of his possession through forcible entry may within 10 days from the filing of the complaint present a motion to secure on the competent court in the action for forcible entry a writ of preliminary mandatory injunction to restore him in his possession. The court shall decide the motion within 30 days from the filing thereof. Loss or termination of possession. A possessor may lose his possession by the abandonment of the thing, by an assignment made to another either by onerous or gratuitous title, by the destruction or total loss of the thing or vehicle because it goes out of commerce, by the possession of another subject to the provisions of Article 537 if the new possession has lasted longer than 1 year, but the real right of possession is not lost till after the lapse of 10 years. Usufruct. Characteristics. The right to enjoy the property of another with the obligation of preserving it from its substance unless the title constituting it or the law otherwise provides. Classification. Usufruct is constituted by law by the will of private persons expressed in acts inter vivos or in the last will and testament by prescription. Usufruct may be constituted on the whole or a part of the fruits of the thing in favor of one more persons simultaneously or successively, and in every case, from or to a certain day purely or conditionally. It may also be constituted on a right, provided it is not strictly personal or intransmissible. Rights and obligations of usufructuary. A real right by virtue of which a person is given the right to enjoy the property of another, with the obligation of preserving it from and substance unless the title constitution it or the law provides otherwise. The right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law otherwise provides. Rights of the owner. The owner, during the usufruct, can exercise all the rights of ownership consistent with enjoyment of the thing by the usufructuary. He can sell or encumber it, and it can be attached by his creditors, but none of these acts can affect the rights of the usufructuary. The grantee can take possession of the property only after the expiration of the usufruct. Easements created can be exercised only insofar as they do not prejudice the usufructuary. Extinction, termination, and extinguishment. Usufruct is extinguished by the death of the usufructuary unless a contrary intention clearly appears by the expiration of the period for which it was constituted, or by the fulfillment of any resolutory condition provided in the title creating the usufruct. B. 3. By merger of the usufruct and ownership in the same person. Number 4. By renunciation of the usufructuary. And 5th, by the total loss of the thing in usufruct. 6. By the termination of the right of the person constituting the usufruct. 7. By prescription. Easements. Characteristics. An entitlement or easement of the right of way requires that the following requisites must be met. First, the domain of estate is surrounded by other immovables and has no adequate outlet to a public highway. 2. There is payment of proper indemnity, Article 649, paragraph 1, and 3rd, the isolation is not due to the acts of proprietor of the dominant estate, Article 649, last paragraph. And 4th, the right of way claimed is at the point least prejudicial to the servient estate, and insofar as consistent with this rule, where the distance from the dominant estate to a public highway may be the shortest. Article 650. The Supreme Court finds that the right of way sought by the respondent is at the point of least prejudicial to the servient estate, and it is the shortest distance to the national highway under the Philippine Highway Act of 1953. Right of way is defined as the lands secured and reserved to the public for highway purposes, whereas highway includes rights of way, bridges, ferries, drainage structures, signs, guardrails, and protective structures in connection with highways being of similar character as roads for public use. A road right of way can be considered as a property of public dominion which is outside the commerce of man and cannot be leased, donated, sold, or be the object of a contract, except insofar as they may be the object of repairs or improvements and other incidental matters. As a property of public dominion akin to a public thoroughfare, a road right of way cannot be registered in the name of private persons under the land registration law and be the subject of a torrents title, and if erroneously included in a torrents title, the land involved remains as such property of public dominion. The failure of the government to register its claim of road right of way on the titles of Commercial Industrial Real Estate Corporation, Philippines Polyamide Industrial Corporation, Development Bank of the Philippines, ABP, and TG Property Inc. is not fatal to its cause. Classification. An easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner. The immovable in favor of which the easement is established is called the dominant estate, that which is subject thereto the servient estate. Servitudes may also be established for the benefit of a community or of one or more persons to whom the encumbered estate does not belong. Easements may be continuous or discontinuous, apparent or non-apparent. Continuous easements are those the use of which is or may be incessant without the intervention of any act of man. Discontinuous easements are those which are used at intervals and depend upon the acts of man. Apparent easements are those which are made known and are continually kept in view by external signs that reveal the use and enjoyment of the same. Non-apparent easements are those which show no external indication of their existence. Easements are also positive or negative. A positive easement is one which imposes upon the owner of the servient estate the obligation of allowing something to be done or of doing it himself. And a negative easement, that which prohibits the owner of the servient estate from doing something which he could lawfully do if the easement did not exist. Easements are inseparable from the estate to which they actively or passively belong. Easements are indivisible. If the servient estate is divided between two or more persons, the easement is not modified, and each of them must bear it on the part which corresponds to him. If it is the dominant estate that is divided between two or more persons, each of them may use the easement in its entirety without changing the place of its use or making it more burdensome in any other way. Easements are established either by law or by the will of the owners. The former are called legal and the latter voluntary easements. Modes of acquiring easements. Continuous and apparent easements are acquired either by virtue of a title or by prescription of 10 years. In order to acquire by prescription the easements referred to in the preceding title, the time of possession shall be computed thus: in positive easements from the day on which the owner of the dominant estate or the person who may have made use of the easement commenced to exercise it upon the servient estate, and in negative easements the day on which the owner of the dominant estate forbade by instrument acknowledged before a notary public the owner of the servient estate from executing an act which would be lawful without the easement. Continuous non-apparent easements and discontinuous ones, whether apparent or not, may be acquired only by virtue of a title. The absence of a document or proof showing the origin of an easement which cannot be acquired by prescription may be cured by a deed of recognition by the owner of the servient estate or by a final judgment. The existence of an apparent sign of easement between two estates established or maintained by the owner of both shall be considered should either of them be alienated as a title, in order that the easement may continue actively and passively unless at the time the ownership of the two estates is divided. The contrary should be provided by the title of conveyance of either of them, or the sign of origin should be removed before the execution of the deed. This provision shall also apply in case of the division of the thing owned in common by two or more persons. Upon the establishment of an easement, all the rights necessary for its use are considered granted. The owner of the dominant estate cannot use the easement except for the benefit of the immovable originally contemplated. Neither can he exercise the easement in any other manner than the previously established. Rights and obligations of the owners of the dominant and servient estates. The owner of the dominant estate may make at his own expense of the servient estate any works necessary for the use and preservation of the servitude, but without altering it or rendering it more burdensome. For this purpose, he shall notify the owner of the servient estate. He shall choose the most convenient time and manner so as to cause the least inconvenience to the owner of the servient estate. Should there be several dominant estates, the owners of all of them shall be obliged to contribute to the expenses referred to in the preceding article in proportion to the benefits which each may derive from the work. Anyone who does not wish to contribute may exempt himself by renouncing the easement for the benefit of the others. If the owner of the servient estate should make use of the easement in any manner whatsoever, he shall also be obliged to contribute to the expenses in the proportion stated saving an agreement to the contrary. The owner of the servant estate cannot impair in any manner whatsoever the use of the servitude. Nevertheless, if by reason of the place originally assigned or of the manner established for the use of the easement, the same should become very inconvenient to the owner of the servant estate, or should prevent him from making any important works, repairs, or improvements thereon, it may be changed at his expense, provided he offers another place or a manner equally convenient and in such a way that no injury is caused thereby to the owner of the dominant estate or to those who may have a right to the use of the easement. The owner of the servient estate retains the ownership of the portion on which the easement is established and may use the same in such a manner as not to affect the exercise of the easement. Mode of extinguishment. Easements are extinguished first by merger in the same person of the ownership of the dominant and servant estates, second by non-user of 10 years with respect to discontinuous easements. This period shall be computed from the day on which they cease to be used, and with respect to continuous easements from the day on which an act contrary to the same took place. And third, when either or both of the estates fall into such condition that the easement cannot be used, but it shall revive if the subsequent condition of the estates or either of them should again permit its use, unless when the use becomes possible, sufficient time for prescription has elapsed in accordance with the provisions of the preceding number. Fourth, by the expiration of the term or the fulfillment of the condition of the easement is temporary or conditional. By the renunciation of the owner of the dominant estate, by the redemption agreed upon between the owners of the dominant and the servant estates. The form or manner of using the easement may prescribe as the easement itself, and in the same way, if the dominant estate belongs to several persons in common, the use of the easement by any one of them prevents prescription with respect to the others. Nuisance. A nuisance is any act, mission, establishment, business, condition of property, or any else which injures or endangers the health or safety of others, annoys or offends the senses, or 3. Shocks, defies or disregards decency or morality, or 4th, obstructs or interferes with the free passage of any public highway or street or any body of water, or 5th, hinders or impairs the use of property. Nuisance is either public or private. Public nuisance affects a community of neighborhood or any considerable number of persons, although the extent of the annoyance, danger, or damage upon individuals may be unequal. A private nuisance is one that is not included in the foregoing definition. Every successive owner or possessor of property interferes or refuses to abate a nuisance, and that property started by a former owner or possessor is liable therefore in the same manner as the one who created it. The abatement of a nuisance does not preclude the right of any person injured to recover damages for its past existence. Lapse of time cannot legalize any nuisance, whether public or private. The remedies against a public nuisance are A. Prosecution under the penal code or any local ordinance, or a civil action, or abatement without judicial proceedings. The district health officer shall take care that one or all of the remedies against a public nuisance are availed of. If a civil action is brought by reason of the maintenance of a public nuisance, such action shall be commenced by the city or municipal mayor. The district health officer shall determine whether or not abatement without judicial proceedings is the best remedy against a public nuisance. A private person may file an action on account of a public nuisance if it is especially injurious to himself. Any private person may abate a public nuisance which is especially injurious to him by removing, or if necessary, by destroying the thing which constitutes the same, without committing a breach of the peace or doing unnecessary injury, but it is necessary that that demand be first made upon the owner or possessor of the property to abate the nuisance, that such demand has been rejected, that the abatement may be approved by the district health officer and executed with the assistance of the local police, and that the value of the destruction does not exceed 3,000 pesos. The remedies against a private nuisance are a civil action or abatement without judicial proceedings. Any person injured by a private nuisance may abate it by removing, or if necessary, by destroying the thing which constitutes the nuisance without committing a breach of the peace or doing unnecessary injury. However, it is indispensable that the procedure for extrajudicial abatement of a public nuisance by a private person be followed. Private person, or a public official extrajudicially abating a nuisance shall be liable for damages if he causes unnecessary injury, or if an alleged nuisance is later declared by the courts to be not a real nuisance. Modes of acquiring ownership. Occupation, donation, prescription. Modes of acquiring ownership: occupation, donation, prescription. Occupation. A registration under the Torts system confirms that the person whose name appears as owner of the land is indeed the true owner. Possession is an incident of ownership. Whoever owns the property has the right to possess it. Possession. Donation. A donation is an act of liberality whereby a person disposes a thing or right gratuitously in favor of another who in turn accepts it. Like any other contract, agreement between the parties must exist. A donation cannot be forced. It cannot arise from compulsion, be borne by a requirement, or otherwise be impelled by a mandate imposed upon the donor by forces that are external to him or her. Section 31st. Section. Typographical error. Compulsion to donate, and concomitant compulsion to accept cannot be sustained as valid. Not only does it run afoul of basic legal concepts, it also fails to withstand a more elementary test of logic and common sense. Prescription. Acquisitive prescription is a mode of acquiring ownership of a real property or immovable property by possessor through requisite lapse of time. Prescription. By prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by law. In the same way, rights and conditions are lost by prescription. Persons who are capable of acquiring property or rights by the other legal modes may acquire the same by means of prescription. Minors and other incapacitated persons may acquire property or rights by prescription either personally or through their parents, guardians, or legal representatives. Prescription, both acquisitive and extinctive, runs against minors and other incapacitated persons who have parents, guardians, or other legal representatives, absentees who have administrators either appointed by them for their disappearance or appointed by the courts, persons living abroad who have managers or administrators, juridical persons except the state and its subdivisions, persons who are disqualified from administering their property have a right to claim damages from their legal representatives whose negligence has been the cause of prescription. Prescription does not run between husband and wife, even though there be a separation of property agreed upon in the marriage settlements or by judicial decree. Neither does prescription run between parents and children during the minority or insanity of the latter, and between guardian and ward during the continuance of the guardianship. Prescription acquisitive and extinctive runs in favor of or against a married woman. Prescription obtained by a co-proprietor or a co-owner shall be benefit the others. Persons with capacity to alienate property may renounce prescription already obtained, but not the right to prescribe in the future. Prescription is deemed to have been tacitly renounced with the renunciation results in the acts which imply the abandonment of the right acquired. All things which are within the commerce of men are susceptible of prescription unless otherwise provided. Property of the estate or any of its subdivisions, not patrimonial in character, shall not be the object of prescription. Creditors and all other persons interested in making the prescription effective may avail themselves thereof, notwithstanding the express or tacit renunciation by the debtor or proprietor. The provisions of the present title are understood to be without prejudice to what in this code by its special laws is established with respect to specific cases of prescription. Prescription already running before the effectivity of this code shall be covered by laws previously in force, but if since the time this code took effect, the entire period herein required for prescription should elapse, the present code shall be applicable even though by the former laws a longer period might be required. An action for reconveyance based on implied or constructive trust must perforce prescribe in 10 years and not otherwise. 10-year prescriptive period begins to run from the date of registration of the deed or the date of the issuance of the certificate of title over the property. Requisites. To determine prescription, what is essential only is that the facts demonstrating the lapse of the prescriptive period were sufficiently and satisfactorily apparent on the record, either in the allegations of the plaintiff's complaint or otherwise established by the evidence. Appearance. Prescription does not run against the plaintiff in actual possession of the disputed land because such plaintiff has a right to wait until his possession is disturbed or his title is questioned for initiating an action to vindicate his rights. Prescription or limitations of actions to recover movables. Actions to recover movables shall prescribe 8 years from the time the possession thereof is lost, unless the possessor has acquired the ownership by prescription for a less period, according to Articles 1132 and without prejudice to the provisions of Articles 559, 1505, and 1133. To recover immovables. Real actions over immovables prescribed after 30 years. This provision is without prejudice to what is established for the acquisition of ownership and other real rights by prescription. Succession. Testamentary succession. Succession. The general provisions. Definition. Succession is a mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another or others either by his will or by operation of law. Succession occurs at the moment of death. The rights to the succession are transmitted from the moment of death of the decedent. Testamentary succession. Wills. Due execution of the will or its extrinsic validity pertains to whether the testator, being of sound mind, freely executed the will in accordance with the formalities prescribed by law. A purported will is not to be denied legalization on dubious grounds. Otherwise, the very institution of testamentary succession will be shaken to its foundation, for even if a will has been duly executed, in fact, whether it will be probated would have to depend largely on the attitude of those interested in the estate of the deceased, Institution of heirs. In Roman law, it was a dishonor to die without an heir, so the institution of heir was particularly obligatory. A will which did not institute an heir is void, for no person could die partly testate and partly intestate. These ideas, however, have long passed beyond the limbo of juridical science, since the Ordenamiento de Alcala. A person can die partly testate and partly intestate, and the will is not invalidated by the mere omission of an heir. The heir may be instituted to succeed to the whole or to an adequate part of the inheritance. The existence of the institution, however, does not depend upon the designation or name which the testator gives to his testamentary disposition. Substitution of heirs. Substitution of heirs, concept of the appointment of another heir so that he may enter into inheritance in default of the heir originally instituted. Substitution is really a conditional institution of an heir. Its object is to present intestate succession or the descent of the estate to those not preferred by the testator. Conditional testamentary dispositions and testamentary dispositions with a term. Due execution of the will or its extrinsic validity pertains to whether the testator, being of sound mind, freely executed the will in accordance with the formalities prescribed by law. The state of being forgetful does not necessarily make a person mentally unsound so as to render him unfit to execute a will. A purported will is not to be denied legalization on dubious grounds. Otherwise, the very institution of testamentary succession will be shaken to its foundation, for even if a will has been duly executed in fact, whether it will be probated would not to depend largely on the attitude of those interested in the estate of the deceased. Testamentary succession referred to intestate. It is a fundamental principle in our law on succession that the will of a deceased person expressed in the form and within the limits laid down by the law must be recognized as the supreme law in the disposition of his estate. Testamentary succession is therefore superior to and preferred over intestate or legal succession. Testamentary. Legitime. Article 1061 of the Civil Code required every compulsory heir and the surviving spouse to bring into the mass of the estate any property or right which he may have received from the decedent during the lifetime of the latter, by way of donation or any other gratuitous title, in order that it may be computed in the determination of the legitime of each heir and on the account of the partition. Legal or intestate succession. General provisions. General provisions. Legal or intestate succession takes place if a person dies without a will or with a void will, or one which has subsequently lost its validity, and the will does not institute an heir to or dispose of all the property belonging to the testator. In such case, legal succession shall take place only with respect to the property of which the testator has not disposed. If the suspensive condition attached to the institution of heir does not happen or is not fulfilled, or if the heir dies before the testator or repudiates the inheritance, there being no substitution and no right of accretion takes place. When the heir instituted is incapable of succeeding is such in cases provided in this code. In default of testamentary heirs, the law vests the inheritance in accordance with the rules hereinafter set forth in the legitimate and illegitimate derivatives of the deceased in the surviving spouse and in the estate. In every inheritance, the relative nearest in degree excludes the more distant ones, saving the right of representation when it properly takes place. Relative in the same degree shall inherit in equal shares, subject to the provisions of Article 1006 with respect to relatives of the full and half-blood, and of Article 987, Paragraph 2, concerning division between the paternal and maternal lines. Relationship. Proximity of relationship is determined by the number of generations Each generation forms a degree. A series of degrees forms a line which may be either direct or collateral. A direct line is that constituted by the series of degrees among the ascendants and descendants. A collateral line is that constituted by the series of degrees among persons who are not ascendants and descendants but who come from a common ancestor. The direct line is either descending or ascending. The former unites the head of the family with those who descend from him. The latter binds a person with those from whom he descends. In the line, as many degrees are counted as there are generations or persons, excluding the progenitor. In the direct line, ascent is made to the common ancestor. Thus, the child is 1 degree removed from the parent, 2 from the grandfather, and 3 from the great-grandparent. In the collateral line, ascent is made to the common ancestor, and the descent is made to the person with whom the computation is to be made. Thus, a person is 2 degrees removed from his brother, 3 from his uncle, who is the brother of his father, 4 from his first cousin, and so forth. Full blood relationship is that existing between persons who have the same father and the same mother. Half-blood relationship is that existing between persons who have the same father but not the same mother, or the same mother but not the same father. If there are several relatives of the same degree, and one or some of them are unwilling or incapacitated to succeed, his portion shall accrue to the others of the same degree, save the right of representation when it should take place. If the inheritance should be repudiated by the nearest relative, should there be one only, or by all the nearest relatives called by law to succeed, should there be several, those of the foreign degree shall inherit in their own right, and cannot represent the personal persons repudiating the inheritance. Right of representation. Representation is a right created by fiction of law, by virtue of which the representative is raised to the place and the degree of the person represented, and acquires the rights which the latter would have if he were living or if he could have inherited. The representative is called to the succession by the law and not by the person represented. The representative does not succeed the person represented, but the one whom the person represented would have succeeded. The right of representation takes place in the direct descending line, but never in the ascending. In the collateral line, it takes place only in favor of the children of brothers or sisters, whether they be of the full or half-blood. In order that representation may take place, it is necessary that the representative himself be capable of succeeding the decedent. Whenever there is succession by representation, the division of the estate shall be made per sterpis, in such manner that the representative or representative shall not inherit more than what the person they represent would inherit, if he were living or could inherit. When children of one or more brothers or sisters of the deceased survive, they shall inherit from the latter by representation. They survive with their uncles or aunts, but if they alone survive, they shall inherit in equal portions. A person may represent him whose inheritance he has renounced. Heirs who repudiate their share may not be represented. Order of intestate succession. Descending direct line. Succession pertains in the first place to the descending direct line. Legitimate children and their descendants succeed the parents and other descendants without distinction as to sex or age, and even if they should come from different marriages. An adopted child succeeds to the property of the adopting parents in the same manner as a legitimate child. The children of the deceased shall always inherit from him in their own right, dividing the inheritance in equal shares. Should children of the deceased and descendants of other children who are dead survive, the former shall inherit in their own right, and the latter by right of representation. The grandchildren and other descendants shall inherit by right of representation, and if any one of them should have died leaving several heirs, the portion pertaining to him shall be divided among the latter in equal portions. If legitimate children survive with legitimate children, the shares of the former shall be in the proportions prescribed by Article 895. In case of the death of an adopted child, leaving no children or descendants, his parents and relatives by consanguinity and not by adoption shall be his legal heirs. ascending direct line. In default of legitimate children and descendants of the deceased, his parents and ascendants shall inherit from him to the exclusion of collateral relatives. The father and mother, living, shall inherit in equal shares. Should one only of them survive, he or she shall succeed to the entire estate of the child. In default of the father and mother, the ascendants nearest in degree shall inherit. Should there be more than one of equal degree belonging to the same line, they shall divide the inheritance per capita. Should there be of different lines but of equal degree, one half shall go to the paternal and the other half to the maternal descendants. In each line, the division shall be made per capita. Provisions common to testate and intestate succession. Right of accretion is a right. Accretion is a right by virtue of which, when two or more persons are called to the same inheritance, device, or legacy, the part assigned to the one who renounces or cannot receive his share, or who died before the testator, is added or incorporated to that of his co-heirs, co-devisees, or co-legatees. In order that the right of accretion may take place in a testamentary succession, it shall be necessary, first, that two or more persons be called to the same inheritance or to the same portion thereof, pro indiviso. That one of the persons thus called die before the testator or renounce the inheritance, or be incapacitated to receive it. The words one half for each, or in equal shares, or any others which, though designating an unequal part, do not identify it by such description as shall make each heir the exclusive owner of determinate property, shall not exclude the right of accretion. In case of money or fungible goods, if the share of each heir is not earmarked, there shall be a right of accretion. In legal succession, the share of the person who repudiates the inheritance shall always accrue to his co-heirs. The heirs to whom the portion goes by the right of accretion take it the same portion that they inherit. The heirs to whom the inheritance accrues shall succeed to all the rights and obligations which the heir who renounced or could not receive it would have had. Among the compulsory heirs, the right of accretion shall take place only when the free portion is left to two or more of them, or to any one of them, and to a stranger. Should a part repudiated be the legitimate, the other co-heirs shall succeed to it in their own right, and not by the right of accretion. In testamentary succession, when the right of accretion does not take place, the vacant portion, the instituted heirs, if no substitute has been designated, shall pass to the legal heirs of the testator, who shall receive it with the same charges and obligations. Accretion shall also take place among devisees, legatees, and usufructuaries, under the same conditions established for heirs. Collation. Every compulsory heir who succeeds with other compulsory heirs must bring into the mass of the estate any property or right which he may have received from the decedent during the lifetime of the latter, by way of donation or any other gratuitous title, in order that it may be computed in the determination of the legitimate of each heir and in the account of the partition. Collation shall not take place among compulsory heirs if the donor should have so expressly provided, or if the donee should repudiate the inheritance, unless the donation should be reduced as in officios. Property left by will is not deemed subject to collation if the testator has not otherwise provided, but the legitimate shall in any case remain unimpaired. When the grandchildren who survive with their uncles, aunts, or cousins inherit from their grandparents in representation of their father or mother, they shall bring to collation all that their parents, if alive, would have been obliged to bring, even though such grandchildren have not inherited the property. They shall also bring to collation all that they may have received from the decedent during his lifetime, unless the testator has provided otherwise, in which case his wishes must be respected if the legitimate of the co-heirs is not prejudiced. Parents are not obliged to bring to collation in the inheritance of their descendants any property which may have been donated by the latter to their children. Neither shall donations to the spouse of the child be brought to collation, but if they have been given by the parent to the spouses jointly, the child shall be obliged to bring to collation one half of the thing donated. Expenses for support, education, medical attendance, even in extraordinary illness, Apprenticeship, ordinary equipment, or customary gifts are not subject to collation. Expenses incurred by the parents in giving their children a professional, vocational, or other career shall not be brought to collation unless the parents so provide, or unless they impair the legitimate, but when their collation is required, the sum which the child would have spent if he had lived in the house in company of his parents shall be deducted therefrom. Any sums paid by a parent in satisfaction of the debts of his children, election expenses, fines, and similar expenses shall be brought to collation. Wedding gifts by parents and ascendants, consisting of jewelry, clothing, and outfit, shall not be reduced as inofficious, except in so far as they may exceed 1/10 of the sum which is disposable by will. The same things donated are not to be brought to collation and partition, but only their value at the time of the donation, even though their just value may not then have been assessed. Their subsequent increase or deterioration, and even their total loss or destruction, be it accidental or culpable, shall be for the benefit or account and use of the donee. In the collation of a donation made by both parents, 1/2 shall be brought into the inheritance of the father, and the other half to that of the mother. That given by one alone shall be brought to collation in his or her inheritance. The donee's share of the estate shall be reduced by an amount equal to that already received by him, and his co-heirs shall receive an equivalent as much as possible in property of the same nature, class, and quality, should the provisions of the preceding article be impracticable. If the property donated was immovable, the co-heir shall be entitled to receive its equivalent in cash or securities at the rate of quotation, and should there be neither cash or marketable securities in the estate, so much of the other property as may be necessary shall be sold at public auction. If the property donated was movable, the co-heir shall only have a right to select an equivalent or of other personal property of the inheritance at its just price. The fruits and interest of the property, subject to collation, shall not pertain to the estate except from the day on which the succession is opened. For the purpose of ascertaining their amount, the fruits and interest of the property of the estate, the same kind and quality as that subject to collation, shall be made the standard of assessment. The co-heirs are bound to reimburse to the donee the necessary expenses which he has incurred for preservation of the property donated to him, though they may not have augmented its value. The donee who collates in kind and immovable which has been given to him must be reimbursed by his co-heirs for the improvements which have increased the value of the property and which exists at the time the partition is effected. As to works made of the estate for the mere pleasure of the donee, no reimbursement is due him for them. He has, however, the right to remove them if he can do so without injuring the estate. Should any question arise among the co-heirs upon the obligation to bring to collation, or as to things which are subject to collation, the distribution of the estate shall not be interrupted for this reason, provided adequate security is given. Partition and distribution of estate. Where there are 2 or more heirs, the whole estate of the decedent is, before its partition, owned in common by such heirs, subject to the payment of debts of the deceased. Partition in general is the separation, division, and assigning of a thing held in common among those to whom it may belong. The thing itself may be divided of its value. Should a person make partition of his estate by an act inter vivos or by will, such partition shall be respected insofar as it does not prejudice the legitime of the compulsory heirs. A parent who, in the interest of his or her family, desires to keep any agricultural, industrial, or manufacturing enterprise intact may avail himself of the right granted him in this article by ordering that the legitime of the other children to whom the property is not assigned be paid in cash. A person may by an act inter vivos or mortis causa entrust the mere power to make the partition after his death to any person who is not one of the co-heirs. The provisions of this and of the preceding article shall be observed even should there be among the co-heirs a minor or a person subject to guardianship, but the mandatory in such case shall make an inventory of the property of the estate after notifying the co-heirs, the creditors, and the legatees or devisees. Every act which is intended to put an end to indivision among co-heirs and legatees or devisees is deemed to be a partition, although it should purport to be a sale and exchange, a compromise, or any other transaction. Every co-heir has a right to demand the division of the estate unless the testator should have expressly forbidden its partition, in which case the period of indivision shall not exceed 20 years as provided in Article 494. This power of the testator to prohibit division applies to the legitime, even though forbidden by the testator. The co-ownership terminates when any of the causes for which partnership is dissolved takes place, or when the court finds for compelling reasons that division should be ordered upon petition of one of the co-heirs. Voluntary heirs upon whom some condition has been imposed cannot demand a partition until the condition has been fulfilled, but the other co-heirs may demand it by giving sufficient security for the rights which the former may have in case the condition should be complied with, and until it is known that the condition has not been fulfilled or can never be complied with, the partition shall be understood to be provisional. In the partition of the estate, equality shall be observed as far as possible, dividing the property into lots or assigning to each of the co-heirs things of the same nature, quality, and kind. Should a thing be indivisible or would be much impaired by its being divided, it may be adjudicated to one of the heirs, provided he shall pay to others the excess in cash. Nevertheless, if any of the heirs should demand that the thing be sold at public auction and that strangers be allowed to bid, this must be done. In the partition, the co-heirs shall reimburse one another for the income and fruits which each one of them may have received from any property of the estate, for any useful and necessary expenses made upon such property, and for any damage thereto through malice or neglect. Should any of the heirs sell the hereditary rights to a stranger before the partition, any or all of the co-heirs may be subrogated to the rights of the purchaser by reimbursing him for the price of the sale, provided they do so within the period of 1 month from the time they were notified in writing of the sale by the vendor. The titles of acquisition or ownership of each property shall be delivered to the co-heir to whom said property has been adjudicated. When the title comprises 2 or more pieces of land which have been assigned to 2 or more co-heirs, or when it covers 1 piece of land which has been divided in between 2 or more co-heirs, the title shall be delivered to the one having the largest interest, and authentic copies of the title shall be furnished to the other co-heirs at the expense of the estate. If the interest of each co-heir should be the same, the oldest shall have the title. Next topic is obligations. An obligation is a juridical necessity to give, to do, or not to do. Obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. Obligations arising from contracts of the force of law between the contracting parties and should be complied with in good faith. Civil obligations arising from criminal offences shall be governed by the penal laws, subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2, Preliminary Title on Human Relations, and of Title 18 of this book, Regulating Damages. Elements of an obligation. In order that debtor may be in default, it is necessary that the following requisites be present: that the obligation be demandable and already liquidated, that the debtor delays performance, and that the creditor requires the performance judicially and extrajudicially. Sources of obligations. Obligations arising from contracts of the force of law between the contracting parties and should be complied with in good faith. As such, the stipulations in contracts are binding on them, unless the contract is contrary to law, morals, good customs, public order, or public policy. Nature and effect of obligations. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family. unless the law or the stipulation of the parties requires another standard of care. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. When what is delivered is determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. If a person obliged to do something fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. When the obligation consists in not doing, and the obligor does what has been forbidden him, it shall also be undone at his expense. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist when the obligation or the law expressly so declare, or when from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or when demand would be useless as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, delay. Neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who, in any manner, contravene the tenor thereof, are liable for damages. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. The fault or negligence of the obligor consists in the commission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person's time of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201 paragraph 2 shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required, except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk. No person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. Usurious transactions shall be governed by special laws. The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as the prior installments shall likewise raise the presumption that installments have been paid. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. Kinds of obligations: pure, every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties, is demandable at once. Conditional and conditional obligations, the acquisition of rights as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event which constitutes the condition. When the fulfillment of the condition depends upon the sole will of the debtor. The conditional obligation shall be void if it depends upon chance or upon the will of the third person. The obligation shall take effect in conformity with the provisions of this code. Obligation with a period or a term. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must be necessarily to come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. Alternative or facultative. A person alternatively bound by different prestations shall completely perform one of them. The creditors cannot be compelled to receive part of one and part of the other undertaking. Joint and solidary obligations. Concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestation. There is solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. A solidary obligation is one in which each of the debtors is liable for the entire obligation, and in each of the creditors is entitled to demand the satisfaction of the whole obligation from any or all of the debtors. Obligations with a penal clause. In obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interests in case of non-compliance if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. Extinguishment. Of obligations. Payment or performance. Loss of the determined thing due or impossibility. Payment. Loss. Condonation, confusion, compensation, novation, extinguishment of obligations, payment or performance, loss of determinate thing, due or impossibility or difficult of performance. As a general rule, the power to rescind an obligation must be invoked judicially and cannot be exercised solely on a party's own judgment that the other has committed a breach of the obligation. Payment means not only the delivery of money, but also the performance in any other manner of an obligation. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Article 1231 of the Civil Code states that the obligations are extinguished either by payment or performance. The loss of the thing due, the condonation or the remission of debt, the confusion or merger of the rights of creditor and the debtor. Confusion or merger. Creditor and debtor, compensation or novation. Condonation or remission of debt. Condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be expressly or impliedly. One and the other kind shall be subject to the rules which govern inofficious donations. Expressly, the condonation shall furthermore comply with the forms of donation. Infusion. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. merger which takes place in the person of the principal, debtor or creditor benefits the guarantors, confusion which takes place in the person of any of the latter does not extinguish the obligation. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. Compensation takes place when two persons in their own right are creditors and debtors of each other. In order that compensation may be proper, it is necessary, first, that each of the obligors be bound principally in the treaty. In order that compensation may be proper, it is necessary that each of the obligors be bound principally, that he be at the same time a principal creditor of the other, that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind, and also of the same quality if the latter has been stated, that the two debts be due, that they be liquidated and demandable, that over neither of them there be any retention or controversy commenced by the third persons, and communicated in due time to the debtor. Novation. Obligations may be modified by changing their object or principal conditions, substituting the person of the debtor, subrogating a third person in the rights of the creditor, in order that an obligation may be extinguished by another which substitute the same. It is imperative that it be so declared in unequivocal terms, or that the old and the new obligations be on every point incompatible with each other. Contracts, general provisions. General provisions. A contract is a meeting of minds between two persons whereby one bind himself with respect to the other to give something or to render some service. The contracting parties may establish any stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. A nominate contract shall be regulated by the stipulations of the parties, by the provisions of Titles 1 and 2 of this book, by the rules governing the most analogous nominate contracts, and by the customs of the place. The contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. The determination of the performance may be left to a third person, whose decision shall not be binding until it has been known to both contracting parties. The determination shall not be obligatory if it is evidently inequitable. In such case, the court shall decide what is inequitable under the circumstances. Contracts take effect only between the parties, their assigns, and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature or by stipulation or by provisions of law. The heir is not liable beyond the value of the property he received from the decedent. If a contract should contain some stipulation in favor of a third person, he may demand its fulfillment, provided he communicated his acceptance to the obligor before its revocation. Mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly and deliberately conferred a favor upon a third person. In contracts creating real rights, third persons who come into possession of the subject of the contract are bound thereby, subject to the provisions of the mortgage law and the land registration laws. Creditors are protected in cases of contracts intended to defraud them. Any third person who induces another to violate his contract shall be liable for damages to the other contracting party. Contracts are perfected by mere consent, and from that moment the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith in usage and the law. Real contracts such as deposit, pledge, and commodatum are not perfected until the delivery of the object of the obligation. No one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. A contract entered into in the name of another by one who has no authority or legal representation, or who has acted beyond his powers, shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed, before it is revoked by the other contracting party. There is no contract unless the following requisites concur: consent of the contracting parties, an object certain which is the object of the contract, the cause of the complication which is established. Formality, reformation of instruments. When there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement. By reason of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to the end that such a true intention may be expressed. If mistake, fraud, inequitable conduct, or accident has prevented a meeting of the minds of the parties, the proper remedy is not reformation of the instrument but annulment of the contract. The principles of the general law on the reformation of instruments are hereby adopted insofar as they are not in conflict with the provisions of this code. When a mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, said instrument may be reformed. If one party has mistaken and the other acted fraudulently and inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. When one party was mistaken and the other knew or believed that the instrument did not state the real agreement, but concealed that fact from the former, the instrument may be reformed. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument, or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. If two parties agree upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with the right of repurchase, reformation of the instrument is proper. There shall be no reformation in the following cases: simple donations inter vivos wherein no condition is imposed, wills when the real agreement is void. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. Reformation may be ordered at the instance of either party or successors in interest, if the mistake was mutual, otherwise not upon a petition of the injured party or his heirs and assigns. The procedure for the reformation of instruments shall be governed by rules of court to be promulgated by the Supreme Court. Interpretation of contracts. The terms of a contract are clear and leave no doubt upon the intention of the contracting parties. The literal meaning of its stipulations shall control. If the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. In order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Words which may have different significations shall be understood in that which is most in keeping with the nature and object of the contract. The usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract, and shall feel the omission of stipulations which are ordinarily established. The interpretation of obscure words or stipulations in a contract shall not favor the party who caused the obscurity. When it is absolutely impossible to settle doubts by the rules established in the preceding articles, and the doubts refer to incidental circumstances of a gratuitous contract, the least transmission of rights and interests shall prevail. If the contract is onerous, the doubts shall be settled in favor of the greatest reciprocity of interests. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract shall be null and void. The principles of interpretation stated in Rule 1, 2, 3 of the Rules of Court shall likewise be observed in the construction of contracts. Article 1370 of the Civil Code is categorically that when the terms of the contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. Defective contracts. Rescissible contracts. The following contracts are rescissible: those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. Those agreed upon in representation of absentees, if the latter suffer the lesion stated in the preceding number. Those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. All other contracts especially declared by law to be subject to rescission. Voidable contracts. Under Article 1344 of the Civil Code, the fraud must be serious to annul or avoid the contract and render it voidable. This fraud or deception must be so material that had it not been present, the defrauded party would not have entered into the contract. In nullifying contracts on the basis of fraud, the same must be established by clear and convincing evidence. The following contracts are voidable or annullable, even though there may have been no damage to the contracting parties. Those where one of the parties is incapable of giving consent to a contract, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. Unenforceable contracts. The following contracts are unenforceable unless they are ratified. Those entered into in the name of another person by one who has been given no authority or legal representation, or who has acted beyond his powers. Those that do not comply with the statute of frauds as set forth in this number. The following cases on agreement hereafter made shall be unenforceable by action unless the same, or some note or memorandum thereof, be in writing and subscribed by the party charged, or by his agent. Evidence, therefore, of the agreement cannot be received without the writing or a secondary evidence of its contents. An agreement that by its terms is not to be performed within a year from the making thereof. A special promise to answer for the default or miscarriage of another. An agreement made in consideration of marriage other than a mutual promise to marry. An agreement for the sale of goods, chattels, or things in action at a price not less than 500 pesos unless the buyer accept and receive part of such goods and chattels for the evidences or some of them of such things in action or pay at the same time such some part of the purchase money, but when a sale is made by auction and entry is made by the auctioneer in his sales book at the time of the sale, the amount and kind of property sold terms of price. An agreement for the leasing for a longer period than 1 year or for the sale of real property of an interest therein. A representation as to the credit of a third person. Third, those where both parties are incapable of giving consent to a contract. Void or inexistent contracts. Void contracts cannot be ratified, and the right to set up the defense of illegality cannot be waived. An absolute simulated or fictitious contract is void, while a relatively simulated contract, when it does not prejudice third person and is not intended for any purpose contrary to law, morals, good customs, public order, public policy, binds the parties to their real agreement. Natural obligations. Under Article 2142 of the Civil Code, such acts give rise to the juridical relation of quasi-contract to the end that no one shall be unjustly enriched or benefited at the expense of another. Obligations are civil or natural. Civil obligations give a right of action to compel their performance. Natural obligations, not being based on positive law but on equity and natural law, do not grant a right of action to enforce their performance, but after voluntary fulfillment by the obligor, they authorize the retention of what has been delivered or rendered by reason thereof. Some natural obligations are set forth in the following articles. When a right to sue upon a civil obligation has lapsed by extintive prescription, the obligor who voluntarily performs the contract cannot recover what he has delivered or the value of the service he has rendered. When, without the knowledge or against the will of the debtor, a third person pays a debt which the obligor is not legally bound to pay, because the action thereon as prescribed, but the debtor later voluntarily reimburses the third person, the obligor cannot recover what he has paid. When a minor between 18 and 21 years of age was entered into a contract without the consent of the parent or guardian, after the annulment of the contract voluntarily returns the whole thing, or price received notwithstanding the fact that he has not been benefited thereby, there is no right to demand the thing or price thus returned. When a minor between 18 and 21 years of age was entered into a contract without the consent of the parent or guardian, voluntarily pays a sum of money or delivers a fungible thing in fulfillment of the obligation, there shall be no right to recover the same from the obligee who has spent or consumed it in good faith. When, after an action to enforce a civil obligation has failed, the defendant voluntarily performs the obligation, he cannot demand the return of what he has delivered or the payment of the value of the service he has rendered. When a testate or intestate heir voluntarily pays a debt of the decedent exceeding the value of the property which he received by will or by the law of intestacy from the estate of the deceased, the payment is valid and cannot be rescinded by the payer. When a will is declared void because it has not been executed in accordance with the formalities required by law, but one of the intestate heirs, after the settlement of the debts of the deceased, pays a legacy in compliance with the clause in the defective will, the payment is defective and irrevocable. Estoppel. The state cannot be put in estoppels by the mistakes or errors of its officials or agents, absent any showing that it had dealt capriciously or dishonorably with its citizens. While estoppel generally does not apply against the government, especially when the case involves the collection of taxes, an exception can be made when the application of the rule will cause injustice against the innocent party. Through estoppel, an admission or representation is rendered conclusive upon the person making it and cannot be denied or disproved as against a person relying thereon. The principles of estoppel are hereby adopted insofar as they are not conflict with the provisions of this code, the Code of Commerce, the rules of court, and special laws. Estoppel may pay or by deed. When a person who is not the owner of a thing sells or alienates and delivers it, and later the seller or grantor acquires title thereto, such title passes by operation of law to the buyer or grantee. If a person, in representation of another, sells or alienates a thing, the former cannot subsequently set up his own title as against the buyer or grantee. A lessee or a bailee is stooped from asserting title to the thing leased or received as against the lessor or bailor. When in contract between third persons concerning immovable property, one of them is misled by a person with respect to the ownership or real right over the real estate, the other is precluded from asserting his legal title or interest therein, provided all these requisites are present. There must be fraudulent representation or wrongful concealment of facts known to the party estooped. The party precluded must intend that the other should act upon the facts as misrepresented. The party misled must have been unaware of the true facts, and the party defrauded must have acted in accordance with the misrepresentation. One who has allowed another to assume apparent ownership of personal property for the purpose of making any transfer of it cannot, if he received the sum for which a pledge has been constituted, set up his own title to defeat the pledge of the property made by the other to a pledge who received the same in good faith and for value. Estoppel is effective only as between the parties thereto, or their successors in interest. Special contracts, sales. With a contract of sale of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. The contract of sale may be absolute or conditional. Parties. The contract of sale is perfected at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. From the moment the parties may reciprocally demand performance subject to the provisions of the law governing the form of contracts. Obligations of the vendor. Under the Civil Code, the vendor shall be answerable for the warranty against hidden defects on the thing sold. In a lump sum contract, a vendor is generally obligated to deliver all the land covered within the boundaries, regardless of whether the real area should be greater or smaller than the recited in the deed. Obligations of the vendee. The vendee is bound to accept, deliver, and to pay the price of the thing sold at the time and place stipulated in the contract. If the time and place should not have been stipulated, the payment must be made at the time and place of the delivery of the thing sold. Transfer of ownership. Article 1477. The ownership of the thing sold shall be transferred to the vendee upon the actual or constructive delivery thereof. Warranties, where the obligation of either party to a contract of sale is subject to any condition which is not performed, such party may refuse to proceed with the contract, or he may waive performance of the condition. If the other party has promised that the condition should happen or be performed, such first mentioned party may also treat the non-performance of the condition as a breach of warranty. Breach of contract. Article 2220 of the New Civil Code provides that to award moral damages in a breach of contract, the defendant must act fraudulently or in bad faith. The Supreme Court cannot award moral and exemplary damages to the petitioner in the absence of fraud on the respondent's part. A breach occurs where the contractor excusably fails to perform substantially in accordance with the terms of the contract. Breach. Extinguishment. Sales are extinguished by the same causes as all other obligations by those stated in the preceding articles of this title, and by conventional or legal redemption. Trusts. A trust receipt transaction is one where the entrustee has the obligation to deliver to the entruster the price of the sale, or if the merchandise is not sold, to return the merchandise to the entrustee. The trust is the right to the beneficial enjoyment of property, the legal title to which is vested in another. Agency. By the contract of agency, a person binds himself to render some service or to do something in representation or in behalf of another, with the consent or authority of the latter. Representation. On behalf. Agency may be expressed or implied from the acts of the principal, from his silence or lack of action, or his failure to repudiate the agency. Knowing that another person is acting on his behalf without authority, the agent is bound by his acceptance to carry out the agency and is liable for the damages which, through his non-performance, the principal may suffer. He must also finish the business already begun on the death of the principal, should delay entail any danger. The principal may comply with all the obligations which the agent may have contracted within the scope of his authority. As for any obligation wherein the agent has exceeded his power, the principal is not bound except when he ratifies it expressly or tacitly. Agency is extinguished by its revocation, by the withdrawal of the agent, by the death, receivable interdiction, insanity or insolvency of the principal or of the agent, by the dissolution of the firm or corporation which entrusted or accepted the agency. Fifth, by the accomplishment of the object or purpose of the agency. And sixth, by the expiration of the period for which the agency was constituted. Compromise is a contract whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. The court shall endeavor to persuade the litigants in a civil case to agree upon some fair compromise. Loan. Loan. Person who receives a loan of money or any other fungible thing acquires the ownership thereof and is bound to pay to the creditor an equal amount of the same kind and quality. A contract whereby one person transfers the ownership of fungible things to another with the obligation on the part of the latter to give things of the same kind, quantity, and quality shall be considered as barter. The obligation of a person who borrows money shall be governed by the provisions of Articles 1249 and 1250 of this Code. If what was loaned is a fungible thing other than money, the debtor owes another thing of the same kind, quantity, and quality, even if it should change in value in case it is impossible to deliver the same kind its value at the time the perfection of the loan shall be paid. No interest shall be due unless it has been expressly stipulated in writing. Contracts and stipulations under any cloak of evidence, whatever intended or circumvent the laws against usury shall be void. The borrower may recover in accordance with the laws on usury in the determination of the interest if it is payable in kind. Its value shall be appraised at the current price of the products or goods at the time of the place of payment. Without prejudice to the provisions of Article 2212, interest due and unpaid shall not earn interest. However, the contracting parties may be stipulation capitalize the interest due and unpaid, which as added principal shall earn new interest. If the borrower pays interest when there has been no stipulation, therefore, the provisions of this code concerning Solutio Indebiti or natural obligations shall be applied as the case may be. Usurious contracts shall be governed by the usury law and other special laws so far as they are not inconsistent with this code. Commodatum, the bailey in commodatum acquires the use of the thing loaned but not its fruits. If any compensation is to be paid by him who acquires the use, the contract ceases to be a commodatum. Consumable goods may be the subject of commodatum if the purpose of the contract is not the consumption of the object, as when it is merely for exhibition. Movable or immovable property may be the object of commodatum. The bailor in commodatum need not be the owner of the thing loaned. Commodatum is purely personal in character. Consequently, the death of either the bailor or the bailey extinguishes the contract. The bailey can neither lend nor lease the object of the contract to a third person. However, the members of the bailey's household may make use of the thing loaned unless there is a stipulation to the contrary or unless the nature of the thing forbids such use. A stipulation that the bailey may make use of the fruits of the thing loaned is valid. Interests on loan. Deposit. A deposit is constituted from the moment a person receives a thing belonging to another with the obligation of safekeeping it and of returning the same. If the safekeeping of the thing delivered is not the principal purpose of the contract, there is no deposit but some other contract. An agreement to constitute a deposit is binding, but the deposit itself is not perfected until the delivery of the thing. A deposit may be constituted judicially or extrajudicially. A deposit is a gratuitous contract except when there is an agreement to the contrary unless the depositary is engaged in the business of storing goods. Only movable things may be the object of a deposit. An extrajudicial deposit is either voluntary or necessary. Lease. Under Article 1659 of the New Civil Code, an aggrieved party in a lease contract may ask for any of the following remedies: the rescission of the contract, rescission and indemnification for damages, only indemnification for damages allowing the contract to remain in force, the nature of an action filed under Article 1389 as well as the prescriptive period of 4 years as provided under the provision do not apply to all rescissible contracts but are limited to specific cases. Under Article 1659 of the New Civil Code, an aggrieved party in a lease contract may ask for any of the following remedies: the rescission of the contract, rescission and indemnification for damages, only indemnification for damages allowing the contract to remain in force. Quasi-contract. Quasi-contracts, Negotiorum Gestii. Showroom. Certain lawful voluntary unilateral acts give rise to juridical relation of quasi-contract to the end, but no one shall be unjustly enriched or benefited at the expense of another. The provisions for quasi-contract in this chapter don't exclude other quasi-contracts which may come within the purview of the preceding article. Negotiorum Gestii. Whoever voluntarily takes charge of the agency, management of the business or property of another without any power of the latter is obliged to continue the same until the termination of the affair and its incidents, or to require the person concerned to substitute him if the owner is in a position to do so. Solutio Indebiti. If something is received and there is no right to demand it and it was unduly delivered through mistake, the obligation to return it arises. Non-titles and deeds. Torrent system, concept and background. It has been emphasized that when the property is registered under the torrent system, the registered owner's title to the property is presumed legal and cannot be collaterally attacked, especially in mere action for unlawful detainer. A torrent system of registration cannot be used to protect a usurper from the true owner, nor can it be used as a shield for the commission of fraud or to permit one to enrich oneself at the expense of others. Certificate of Title under Section 47 of the Property Registration Decree or Presidential Decree 1529. No title to registered land in derogation of the title of the registered owner shall be acquired by prescription or adverse possession. Every person dealing with registered land may safely rely on the correctness of the certificate of title issued therefore and is in no way obliged to go beyond the certificate to determine the condition of the property. Exceptions when the party has actual knowledge of facts and circumstances that would impel a reasonably cautious man to make further inquiry, when the buyer has knowledge of a defect or the lack of title in this vendor, when the buyer mortgages a bank and an institution of a similar nature, as they are enjoined to exert higher degree of diligence, care and prudence than individuals in handling real estate transactions, agrarian titles and ancestral lands and domains. Under Republic Act No. 6657 and DA01, the awarded lands may only be transferred or conveyed after 10 years from the issuance and registration of the Emancipation Patent or Certificate of Land Ownership Award, considering that the EPs and CLOAs have not yet been issued to the qualified FWBs. In the instant case, the 10-year prohibitive period has not even started. Significantly, the reckoning point is the issuance of EP or CLOA and not the placing of the agricultural lands under CARP coverage. The titling of ancestral lands is for the purpose of officially establishing one's land as an ancestral land, just like a registration proceeding. The titling of ancestral lands does not vest ownership upon the applicant but only recognizes ownership that has already vested in the applicant by virtue of his property. Comprehensive Agrarian Reform or CARP covers the following lands: all alienable and disposable lands of the public domain devoted to or suitable for agriculture, all lands of the public domain exceeding the total area of 5 hectares and below to be retained by the landowner, all government-owned lands that are devoted to or suitable for agriculture, all private lands devoted to or suitable for agriculture regardless of the agricultural products raised or can be raised on these lands. The Comprehensive Agrarian Reform Law covers all public and private agricultural lands as provided in Proclamation No. 131 and Executive Order No. 229, including other lands of the public domain suitable for agriculture regardless of tenurial arrangement and commodity produced. Suitable for agriculture. Waste public. Proclamation No. 131, Executive Order No. 229. Public domain suitable for agriculture regardless of tenurial arrangement and commodity produced. However, maximum of 5 hectares of the landowner's compact or contiguous land holdings may not be distributed to qualified beneficiaries. It is within the landowner's rights to retain this area. Comprehensive Agrarian Reform Program covers the following lands. The 1987 Constitution mandates the just distribution of all agricultural lands subject to the limits prescribed by Congress under Article 2, Section 21 of the Constitution. The state shall promote comprehensive rural development and agrarian reform. Article 13, Section 4 provides that an agrarian reform program should be carried out in the country. The state shall by law undertake an agrarian reform program founded on the rights of farmers and regular farm workers who are landless to own directly or collectively the lands they till, or in the case of farm workers to receive a just share of the fruits thereof. To this end, the state shall encourage and undertake the just distribution of all agricultural lands subject to such priorities and reasonable retention limits as the Congress may prescribe, taking into account ecological, developmental, or equity considerations subject to the payment of just compensation. In determining retention limits, the state shall respect the right of small landowners. The state shall further provide incentives for voluntary land sharing. The elements to constitute a tenancy relationship are the following: undoubtedly certain areas that are claimed as ancestral domains may still under the administration of other agencies of the government such as DAR with respect to agricultural lands, DANR with respect to timber, forests, and mineral lands, upon the certification of these areas as ancestral domains, following the procedure outlined in sections 51 to 53 of the IPRA, jurisdiction of the government agency or agencies concerned over lands for the part thereof ceases. Torts. Torts, wherever by act or omission causes damage to another, there being fault nor negligence is obliged to pay for the damage done. Such faults or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Responsibility for fault or negligence under the preceding article is entirely separate and distinct from the civil liability arising from negligence under the penal code. But the plaintiff cannot recover damages twice for the same act or omission of the defendant. Provisions of Article 1172 to 1174 are also applicable. Quasi-delict, when the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages, but if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the court shall mitigate the damages to be awarded. The obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those of persons for whom one is responsible. The father, in case of his death or incapacity, the mother, are responsible for the damages caused by the minor children who live with their company. Guardians are liable for damages caused by the minors or incapacitated persons who are under their authority and live in their company. The owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of their functions. Employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The state is responsible in like manner for the impacts to a special agent, but not when the damage is being caused by the official whom the task done properly pertains, in which case Article 2176 shall be applicable. Lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices so long as they remain in their custody. Responsibility treated or in these articles is the persons herein mentioned prove that they observe all the diligence of a good father of a family to prevent damage. Whoever pays for the damage caused by his dependents or employees may recover from the latter what he has paid or delivered in satisfaction of the payment. If the minor or insane person causing damage has no parents or guardian, the minor or insane person shall be answerable for his own property in an action against him by guardian and adding to the shall be appointed. An animal or whoever may make use of the same is responsible for the damage which it may cause. Although it may escape or be lost, their responsibility shall cease only in case of damage should become from a force majeure or from the fault of the person who has suffered damage. In motor vehicle mishaps, the owner is solidarily liable with his driver if the former, unless there is proof to the contrary, it is presumed that the person driving a motor vehicle has been negligent if at the time of the mishap he was violating any traffic regulation. Every owner of a motor vehicle shall file negligence. Negligence is defined as the failure to observe for the protection of the interests of another person the degree of care, precaution, and vigilance that the circumstances justly demand, whereby such other person suffers injury. Negligence. Damages, general consideration, actual, compensatory, moral, nominal, temperate, moderate, liquidated, exemplary, or corrective. Actual and compensatory. Basic is the rule that to recover actual damages, not only must the amount of loss be capable of proof, it must also be actually proven with a reasonable degree of certainty, premised upon competent proof or the best evidence available. Moral, under Article 2219 of the Civil Code, moral damages are recovered in the following analogous cases: criminal offense, physical injuries, quasi-delict, seduction, abduction, rape, or other lascivious acts, adultery, concubinage, illegal or arbitrary detention or arrest, illegal search, libel, slander, or any other form of defamation, malicious prosecution, acts mentioned in Article 309, acts and actions referred in Articles 21, 26, 27, 29, 30, 32, 34, and 35. In case of breach of contract, moral damages may be recovered only if the defendant acts fraudulently or in bad faith, was guilty or gross negligence amounting to bad faith or in wanton disregard of his contractual obligations. Nominal. Nominal damages are recoverable where a legal right is technically violated and must be vindicated against an invasion that has produced no actual present loss of any kind, or where there has been a breach of contract and no substantial injury or actual damages whatsoever have been or can be shown. Temperate, in the absence of competent proof on the amount of the actual damages suffered, a party is entitled to receive temperate damages. The amount thereof is usually left to the sound discretion of the courts, but the same should be reasonable, bearing in mind that temperate damages should be more than nominal but less than compensatory. Liquidated, the stipulation for liquidated damages is attached to an obligation in order to ensure performance in a double function to provide for liquidated damages, and 2. to strengthen the coercive force of the obligation by the threat of greater responsibility in the event of breach. Exemplary as to the award of exemplary damages, Article 2229 of the Civil Code provides that exemplary damages may be imposed by way of example or correction for the public good in addition to the moral, temperate, liquidated, or compensatory damages. Damages in case of death. Subsequently, quasi-delict, the negligence or fault should be clearly established because it is the basis of the action, whereas in breach of contract, the action can be prosecuted merely by proving the existence of the contract with the fact that the owner, in this case of a common carrier, failed to transport his passenger safely in his destination. In case of death or injuries of the passengers, provides that common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary negligence as defined in Articles 1733, 1755. Graduation of damages. In crimes, when a criminal action is instituted, civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with a criminal action unless the offended party waives the civil action, reserves the right to institute it separately or institute the civil action prior to the criminal action. A civil action is based on an obligation not arising from the act or omission complained as a felony. In no case may the offended party recover damages twice for the same act or omission charged in the criminal action. In case of quasi-delicts, the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. But if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be awarded. Contracts and quasi-contracts, in case both parties have committed a breach of the obligation, the liability first infractor shall be equitable, tempered by the courts if it cannot be determined which of the parties first violated the contract. The same shall be deemed extinguished and each shall bear his own damages. Liquidated damages. Liquidated damages, whether intended as an indemnity or a penalty, shall be equitable, reduced if they are iniquitous or inconscionable. What committed by the defendant is not one of the parties agreeing upon the liquidated damages. The law shall determine the measure of damages and not the stipulation. The courts may mitigate the damages to be paid by the losing party once shown a sincere desire for a compromise. So that concludes the whole civil law. Verba Juris Bar Review Notes, Volume 1, Civil Law. So that concludes the civil law portion of the book. So next is taxation.